Our law then differentiates between the eviction of unlawful occupiers of residential property and the eviction of lawful or previously lawful occupiers of rural or farmlands. The eviction of unlawful occupiers of residential property is dealt with by PI, while the eviction of lawful or previously lawful occupiers of rural or farmland is dealt with by ESTA. The focus of this presentation will thus look at the procedure in terms of PI. The effect that the current COVID-19 pandemic has had and will continue to have on a tenant's ability to meet their rental obligation needs no explanation. But it is not just tenants who have been adversely affected. The financial circumstances of landlords have also and will continue to change. Forecasting suggests that we are yet to feel the real economic pinch. Banks have given a large number of bondholders payment holidays for the time being, but all this is going to do is push the cost further down the line. The problem is not now. The problem will most likely arise 4 to 5 months down the line. Why? Why? Expenses have built up, payment holidays have stopped, rental deposits can no longer be used to cover arrear rent, and the costs of tenant placing a financial burden on the landlord will only increase. The eviction process, focusing specifically on residential lease agreements. It is important to note from the outset that the process is not a quick one. Let's take a quick look at the legislation regulating the eviction of unlawful occupiers of residential property. As already discussed, this is governed by PI, which is to be read against the backdrop of Section 26 of the Constitution. A few commonly asked questions. Can landlords apply for eviction orders under Level 4 regulation? Landlords can commence eviction applications and even obtain an eviction order. The next question being, can tenants then be evicted under Level 4 regulations? Eviction orders cannot be served or executed. There is a stay of execution on eviction orders regarding residential property under Level 4 Regulation 19. Should a landlord find themselves in a situation where their tenant has not been able to meet their rental obligations, they should not take the law into their own hands. They must not disconnect electricity and water, change the locks, prevent the tenant from entering the rented premises, nor should they remove the tenant's belongings from the rented property or threaten the tenant in any way. It is important to note that before the landlord decides to start with the eviction process, it is wise to ensure that the landlord and the tenant have at least attempted to reach a temporary compromise by either way of rental deferment or any other measure they deem appropriate during the time. Why is this important? The court will be reluctant to grant an order if the landlord has allowed the tenant any kind of leeway, despite the tenant's efforts to request a leeway during this time, especially if the landlord is in a financial position to do so, by either way of offering a rental deferment or a rental reduction. How to start the process. Step 1 is to issue a letter of demand or a breach letter. The tenant will then either be able to remedy their breach within the specified time frame or they will not. Failure of the tenant to remedy their breach will allow the landlord to cancel the agreement. It is best to consult the services of an attorney, preferably ourselves, as the failure to include certain facts or make certain allegations will only cause the landlord problems further down the line. The letter of demand must be a formal written letter. It must disclose the cause of action, i.e. the breach of contract, and that the tenant must be advised why they are in the breach of the agreement. It must call on the tenant to remedy their breach within a certain number of days. Most lease agreements contain a breach clause which will state the number of days within which the tenant has to remedy their breach. If the tenant fails to remedy their breach, you may begin formal eviction proceedings in order to evict the tenant, now known as the unlawful occupier. According to PI, an unlawful occupier is a person who occupies land without the express or tacit consent of the owner or person in charge of such land. Remember that a separate action will need to be instituted for the payment of arrear rental. The actual procedure. In the bigger picture, this is a three-step process and is where confusion reigns. Different magistrates' courts have adopted different practices, and there is also a variation between the High Court and Magistrates' Court. For this reason, we will just provide a brief outline and keep things quite simple. In terms of PI, effectively two applications are made to the court. Step 1, which is the first application, is an application whereby the landlord or applicant applies to the court for permission to proceed with the issuing of the second application. The first application will set out the grounds upon which the applicant or landlord relies. These are set out in an affidavit which is deposed to by the applicant or landlord. If the first application is successful, the court will allow the second application to be issued and will set a date when the second application should be heard. Assuming the order sought in the first application is granted, the second application will be served by a sheriff on the unlawful occupier. Step 2, which is the second application. Simply put, this is the main application. It advises the unlawful occupier that the landlord has instituted proceedings to have them evicted and the basis or grounds for such application. The second application is when the landlord or applicant requests that the court grant an order evicting the unlawful occupiers. If the relief sought is granted, the court will allow the eviction of the unlawful occupiers. It is important to bear in mind that before granting the relief, the court takes into account a number of factors, such as, does the tenant have children? Is it a household headed by women? Or are there vulnerable members of society, such as young children or elderly grandparents? Step 3. This is the actual eviction and is carried out by the sheriff of the court. It is not to be carried out by the landlord. The services of a locksmith can be employed to gain access to the premises if needs be. Let's look at some interesting points and some golden nuggets of information. It is interesting to note that in the second application, the details of the legal aid board are to be provided to the unlawful occupier. This is to promote the notion of access to justice. Reference to Section 26 of the Constitution. The unlawful occupier must be advised that they have the right to access to adequate housing, which right includes the right not to be evicted from their home or to have their home demolished without an order of court made after considering the relevant circumstances. And the final fact, which applies to both applications, is that the municipality should be cited and served with the application. This links back to the constitutional right mentioned above, that everyone should have the right to adequate housing and the corresponding duty this right places on the municipality to provide adequate housing. If there is a situation where people will essentially be left homeless, it is important to mention that there is a duty imposed on the local government, i.e. the municipalities of South Africa, to provide alternative accommodation to such persons. This above principle has been confirmed in numerous cases centered around the PI Act, the most noteworthy of them all being the Grootboom judgment, which held that the emergency shelter must be provided for those with no access to land, no roof over their heads, and who are living in intolerable conditions or crises situations. The court may, in instances, grant an alternative accommodation order. However, the surrounding circumstances of the order will be viewed on a case-by-case basis. Let's have a quick look at commercial leases and the process that may need to be followed in the event that you wish to evict a commercial tenant. It is important to note that PI and ESTA do not apply to the eviction of a commercial tenant. The eviction of a commercial tenant is governed by contract and the common law. The process is started with the issuing of a breach letter. In the Madge Court, you are to proceed by way of action proceedings, and in the High Court, you may proceed by way of action or application proceedings. The landlord's tacit hypothec is a form of real security recognized in South African law. The hypothec is a tacit because it is understood or implied without being stated. In other words, the hypothec comes into effect by operation of law and not by agreement between the landlord and tenant. The hypothec secures the lessee's obligation to pay the rent in terms of the agreement of lease. It does this by allowing the landlord to burden the movables present on the leased land or while in transit to a new destination, subsequent to the removal from the land. What this means is that the landlord is able to obtain a limited real right in the movable goods present on the property on the date that rent is in arrears. However, this right does not accrue to the landlord automatically. It first needs to be perfected. In other words, the landlord has to obtain an interdict restraining the removal or sale of the goods on the property, pending an action for rent or an order for their attachment by the court. In conclusion, it is important to remember that when it comes to residential evictions, the tenant is strongly protected by PI. That said, the court will always try and balance the rights of the landlord as homeowner against the right of the tenant against the backdrop of the Constitution. The process may seem quite a simple one, but is fraught with hurdles along the way. The courts will not grant an eviction order easily, but provided the landlord has complied with Section 4 of PI and no valid defence is raised by the unlawful occupier, the court must grant the eviction order. In the case of commercial evictions, the rights of the property owner are protected, and the right of the property owner to protect commercial income take priority. Due process must, however, still be followed. Let's look at some commonly asked questions. First question, can the landlord keep or withhold the deposit? If the rent has not been paid, the landlord may withhold the deposit. This is one of the reasons why a deposit is paid. Second question, what if you are the tenant and you are battling to pay your monthly rent? Landlords and tenants must try and reach a middle ground. Tenant must communicate with the landlord and hopefully reach a temporary solution. The tenant must correspond with the landlord by providing an income declaration form as evidence of their inability to pay their rent. They can either decide to do a rent deferment or utilize the rental deposit. The landlord can allow for any measure which is financially viable for them. The landlord is not obliged to allow the tenant a rental holiday, but in light of the current circumstances, we strongly encourage open channels of communication between the landlord and tenant. Thank you all for joining me today, and if you have any questions, please do not hesitate to email myself at the email address provided below or Danny.